Big news out of the Supreme Court. The Chief Justice of the United States of America just issued a rare statement on President Trump's call to impeach the judge in his Alien Enemies Act case. I want to go straight to Paula Reed. Paula, wow, this is a very big deal.
This is a huge deal. Here you have Chief Justice John Roberts appearing to push back on statements President Trump made earlier today, suggesting that a judge, James Boasberg, who of course temporarily blocked deportations by the Trump administration, or at least tried to, should be impeached. And here the Chief Justice writes, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose." Now, this is, of course, a very short statement, but it says so much.
Hello, friends. Subscribe to the channel. Big news coming out of the Supreme Court. The Chief Justice of the United States has issued a rare public statement in response to President Trump's remarks calling for the impeachment of a judge involved in the Alien Enemies Act case. Let's go straight to Paula Reed. Paula, this is a significant development. It really is a major moment. Chief Justice John Roberts appears to be directly responding to President Trump's earlier comments suggesting that Judge James Boasberg, who temporarily blocked deportations tied to the administration's actions, should be impeached. In his statement, the Chief Justice emphasized a long-standing principle of the judiciary. He noted that for more than 2 centuries, it has been understood that impeachment is not the appropriate response to disagreement with a judicial ruling. Instead, he pointed out that the proper channel for challenging such decisions is through the normal appellate review process. Although the statement is brief, its message is clear and carries considerable weight.
Because earlier today, in a Truth Social post, President Trump sort of went on a tangent about how angry he was at this judge and saying this judge, like many of the crooked judges I am forced to appear before, should be impeached. And this comes just several days after Boasberg tried to temporarily block some deportations by the Trump administration, and the Trump administration did not abide by his order to turn around 2 planes that had already taken off. And in a pretty heated hearing yesterday, the Justice Department insisted that they did not need to abide by the judge's oral order from the bench, something the judge took issue with. And then even when the judge had issued a written order, they still did not comply. And in court yesterday, they were arguing that the reason they did not need to comply with that written order is because they said that President Trump has a broad executive authority when it comes to foreign affairs. And the reason that this whole case is significant, Dana, is because this is not just another test of Trump's expansive use of executive power. It is also a test of the extent to which he and his lawyers believe he can be checked by the courts. So here, Judge Boasberg getting some support from really the most senior justice in the land.
Yeah, your eyes are.
So, what just happened, guys? According to this framing, it's being described as a major shock to the American political system. Not in an abstract or distant sense that historians will analyze years from now, but as a sudden and highly visible moment that unfolded in real time and immediately drew national attention. In this interpretation, the statement suggests a dramatic break in tone and emphasizes the significance of a sitting Chief Justice of the United States Supreme Court, one of the 9 key figures responsible for interpreting the Constitution, entering the public conversation in response to a political controversy. It portrays the moment as one that quickly spread across media coverage and became part of the broader national political discussion.
Going wide, David Chalian.
It's astonishing, and I don't want to diminish the importance of the specific case that
But this
Paul
is
is
about
saying.
that.
It is, obviously, but it's so much bigger than
Yeah.
that, too. This is, I just want to step back here, because there are so many people, I think, that said in the last couple days of, well, are we in a constitutional crisis or not? And are they really defying an order? Or let's parse whether it was a written order or a verbal order. It's too early, it's too soon to get worked up about this or concerned about this. And John Roberts, who does not choose to jump into the political fray at all if he doesn't have to, says, no, 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 it's not too soon. I am the guy that sits atop one of the 3 co-equal branches as designed by the Constitution, and it's not too soon for me to say, back off, Mr. President. You should not be talking about impeaching a district judge, a district-level judge, because you don't like the rules.
Yeah, a Supreme Court justice stood up during a live public event, turned away from the President of the United States and simply walked out. Just walked out in full view of the cameras, witnesses, and the entire world. And the reason wasn't a scheduling issue or a medical emergency. They left because the president, while speaking at the podium, was openly and directly attacking the Constitution of the United States, criticizing the very foundation that gives the Supreme Court its authority, legitimacy, and role in government. This is not a rumor being quietly circulated inside political circles. This is not anonymous speculation coming from unnamed officials.
That's not the way the last 2 centuries have worked. And so I think, he doesn't get involved very often. The fact that he's chosen to step in here, you see he's responding to what Trump put in that Truth Social this morning.
Right, which I'll get to in a
but
second.
But also just the aggressiveness to push back on Trump this way, choosing to speak and speaking the way he did in this statement, we should all take note of this moment.
Okay, I'm not sure if we have it yet because we just got it to put up on the screen, but I'm just going to read it one more time, and it being John Roberts' statement, which we just got a few moments ago. For more than 2 centuries, it has been established that the impeachment is not an appropriate response to disagreement concerning a judicial decision.
Actively and unapologetically attacking the Constitution of the United States, criticizing the very document that gives the Supreme Court its authority, its legitimacy, and its entire foundation for power. This is not a leaked story that officials are now rushing to deny. This is not anonymous speculation coming from unnamed sources. It's extraordinary. And I don't want to minimize what this specific case is about. It clearly matters, but the implications go far beyond it. Because there has been a broader question building in recent days. Are we actually in a constitutional crisis or not? Are these actions crossing a legal line? Or are people just reacting too quickly? Some argue it's too early to make that call, too soon to raise alarms, too soon to define it in those terms. And then John Roberts, who almost never steps directly into political controversy unless absolutely necessary, effectively says, no, this is not something to shrug off. He makes it clear that he sits atop one of the 3 co-equal branches of government, exactly as the Constitution designed it. And in that role, he is signaling that it is not appropriate for the president to talk about impeaching a district judge simply because he disagrees with a ruling. It is a direct public line being drawn in real time.
The normal appellate review process exists for that purpose. Okay, now let me catch up our viewers. And you saw it a little bit on the screen, but I just want to point specifically to what this is in response to Donald Trump's post. Here's what Donald Trump said. This radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama, was not elected president. He went on to say, I'm just doing what the voters wanted me to do. This judge, like many of the crooked judges I am forced to appear before, should be impeached. Now, before we continue our conversation, I just want to add another layer to this, which is, remember what Donald Trump said just on Friday, which was, I don't know, what, four days ago, when he was at the Justice Department about a different judge.
In the high-stakes, high-wire act of modern American politics and entertainment, there are few moments more explosive than a direct clash between institutional power and unfiltered confrontation. And this week, that collision didn't just stay in the background of legal debates or political commentary. It broke into the open in a way that has stunned observers across the country. We are not talking about a slow-moving academic discussion that historians will analyze years from now. We are talking about a sharp, immediate moment that erupted on live television and quickly became part of a much larger national argument about the state of American democracy. A sitting justice of the United States Supreme Court, one of the 9 central pillars of the constitutional system, reportedly stood up during a live public appearance and walked out. Not slowly, not quietly, just walked out in full view of cameras, witnesses, and a national audience. And according to accounts of the moment, the reason was not logistical. It wasn't a scheduling conflict or a personal emergency. It was the President of the United States speaking at the podium, making remarks that were widely interpreted as a direct attack on the Constitution itself, the very framework that gives the Supreme Court its authority, its legitimacy, and its role in governing the nation. This is not a rumor being quietly denied behind closed doors. This is not vague speculation filtered through anonymous sources. It's astonishing. And it matters far beyond the specifics of the event itself, because it feeds into a much larger question that has been hanging over the political system in recent days. Are we witnessing a constitutional crisis, or just routine political conflict being amplified by media and partisanship? Some argue it is too early to make dramatic conclusions, that these disputes are part of the normal push and pull between branches of government, that legal disagreements should be resolved through appeals, not alarm. But then comes a rare intervention from Chief Justice John Roberts, someone who almost never steps directly into political controversy unless he believes the institutional boundaries are at risk. In a public statement, Roberts emphasized a principle that has been settled for over 2 centuries. Impeachment is not a legitimate response to disagreement with a judicial decision. The proper remedy, he reminded the country, is the appellate process. In other words, if a ruling is contested, the answer is legal appeal, not political retaliation against judges themselves. The tone was restrained, but the message was unmistakable. The boundaries of constitutional governance are being tested in real time, and they matter. To understand why this moment has escalated so quickly, you have to look at the underlying conflict driving it. At the center of the controversy is a federal judge, James Boasberg, whose rulings in cases involving Trump administration policy have triggered sharp political backlash. In response to those rulings, Trump publicly attacked the judge, calling him a lunatic, and calling for impeachment, not based on allegations of corruption or criminal conduct, but based on disagreement with judicial decisions. And that distinction is where the constitutional tension becomes most serious. Impeachment is not designed as a tool for political disagreement. It is reserved for misconduct at the highest level, treason, bribery, or other serious abuses of office. It is not meant to function as a response mechanism for losing a court case. But the rhetoric being used transforms it into exactly that, a pressure tactic aimed at judges whose rulings are politically unfavorable. Behind all of this is a deeper legal argument that has intensified the confrontation even further. The administration has advanced an expansive interpretation of executive power, particularly in areas like national security, immigration, and trade. The argument suggests that, in these domains, presidential authority should be extremely broad, so broad that judicial oversight becomes minimal or, in some interpretations, effectively irrelevant. Supporters frame this as necessary for effective governance in high-stakes areas. Critics argue it moves dangerously close to eliminating the concept of judicial review altogether, because if courts cannot meaningfully review executive actions in major policy areas, then the constitutional system of checks and balances begins to weaken at its core. This is the tension that has now reached the highest levels of the judiciary and why reactions have been so strong. The reported walkout by a Supreme Court justice is being interpreted by some observers as symbolic institutional resistance, a refusal to normalize rhetoric or behavior that appears to challenge the authority of the Constitution itself. Meanwhile, Roberts' statement reinforces a different kind of resistance, procedural, legal, and grounded in long-standing constitutional norms. Together, these reactions highlight a system under strain, where the usual quiet boundaries between branches of government are becoming more visible and more contested. The cases now moving toward the Supreme Court will only intensify this dynamic. Disputes over tariffs, immigration enforcement, and executive emergency powers are converging on a single question: how far does presidential authority actually extend, and where do the courts draw the line? That question is no longer theoretical. It is now being tested in real cases with real consequences. And the difficulty facing the court is not just legal, it is institutional, because whatever the justices decide, they are operating in a political environment where their legitimacy is constantly being challenged from multiple directions. If they rule against the president, they face political backlash. If they rule in favor, they risk reinforcing claims of unchecked executive authority. It is a narrowing space for neutral ground. At the same time, constitutional scholars warn that something broader may be unfolding, not a single crisis event, but a gradual erosion of norms. A slow shift where previously unthinkable actions become normalized over time, changing the baseline of what presidential power is assumed to be. And that is where the deeper concern emerges, because constitutional systems do not usually fail in a single dramatic moment. They shift incrementally as boundaries are tested repeatedly and responses become less forceful over time. The central fear is not just about one decision or one controversy. It is about whether the system can continue to enforce limits when those limits are increasingly contested by political actors and their supporters. In that sense, the walkout, the judicial statement, and the political rhetoric are not separate incidents. They are part of a broader pattern of escalating tension between branches of government. And as these cases move forward, the system is heading toward a series of defining tests. Tests of executive power, tests of judicial authority, and ultimately, tests of whether the traditional balance between branches can still hold under sustained political pressure. What happens next will not just shape policy outcomes. It will shape the working definition of constitutional government itself.